If you asked our Florida Republican political leaders if they are constitutional originalists, I'm pretty sure they'd all say yes. Ron DeSantis, Rick Scott, Marco Rubio. Pretty sure if you asked any of them directly, they'd all answer in the affirmative. So the other day, I got to thinking, what would a constitutional originalist say about the modern criminal justice system? And I recorded this video. It got really intense pretty quickly. It requires no subtlety of mind to understand that when the Founding Fathers enshrined the right to a jury trial in the Sixth Amendment, they did not intend for it to be an optional privilege exercised at the leisure of a bloated prosecutorial bureaucracy. It was not a suggestion for how cases might be disposed of. It was a guarantee as fundamental to our structure of government as the very existence of trial courts themselves. And yet, what we have today in our criminal justice system is not the robust procedural safeguards envisioned by the framers, but a factory of guilty pleas driven not by due process, but by bureaucratic efficiency. There is nothing constitutional about a justice system that functions entirely on the assumption that trials must be avoided. To say that a right is guaranteed, but then render it nearly impossible to exercise, is to make a mockery of the very concept of rights. The government, in its infinite wisdom and administrative ingenuity, has managed to do precisely this. It has so burdened the exercise of the right to a jury trial with delay, risk, and punishment that it has become a right in name only. It is a constitutional fiction, a hollow recitation of legal tradition that bears no resemblance to the structure of government set forth by the founders. Let us examine this regime with the scrutiny that it deserves. The Sixth Amendment, in its clarity, states, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. All criminal prosecutions, not some, not a handful, not an administratively feasible percentage, all. And yet in Florida and throughout the country, we see a system where trials are held in 2 to 5% of felony cases. The government would have us believe that this is the voluntary choice of defendants, that the accused, with all the uncoerced free will of a man facing decades in prison, has simply elected to forego his right to a trial. But when the government sets up a system in which exercising a constitutional right is met with greater punishment than waiving it, that is not a voluntary choice. That is compulsion, forbidden by the very structure of our constitutional order. The constitutional order we inherited from Madison, from Hamilton, from Jefferson, from Washington, did not envision prosecutorial extortion masquerading as judicial economy. The system, as it was designed, did not allow for government officials to threaten an individual with 10 years in prison unless he chooses to accept 2 years instead. Such a system does not punish crime. It punishes the assertion of constitutional rights. The greatest trick that the modern administrative state has played is convincing the public that the Constitution must take a backseat to government efficiency. In this case, we're told that trials take too long, that they cost too much, that it's simply impractical to run a system where every defendant receives what the founders explicitly guaranteed. But since when does the inconvenience of government dictate the scope of a constitutional right? The enumerated powers of the government are few and finite, yet we are to believe that the explicit and absolute right to a jury trial must give way to budget spreadsheets? This is nonsense. The Constitution does not yield to bureaucratic necessity. The Sixth Amendment does not contain a footnote limiting its application to those cases where it is administratively convenient. The Bill of Rights does not read, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial unless the state finds it more cost-effective to avoid one." This idea that trials must be rationed is utterly foreign to our constitutional tradition. The entire purpose of the jury trial system was to prevent government overreach and to place the power of conviction in the hands of the people, not government officials desperate to clear dockets and maintain conviction rates. The founders clearly understood what too many modern jurists and bureaucrats have clearly forgotten. When the government controls both the charging process and the method by which cases are resolved, that natural tendency is towards tyranny. The jury trial was specifically designed to obstruct government power, to stand in the way of a state apparatus that would otherwise run roughshod over the rights of the accused. But instead of respecting this design, we've allowed the government to sidestep the entire system by making trials functionally impossible. Nowhere in the Constitution is the government given the power to punish individuals for demanding the rights the Constitution explicitly gives them. Yet this is precisely what the modern plea bargain system does. Imagine if the government applied this logic to the First Amendment. Suppose a citizen wished to petition his government for redress of grievances. But before he could do so, he was told, "You may petition, but if you do, we will impose 10 times the penalty that you would face if you simply remain silent." This would be laughed out of court. The doctrine of unconstitutional conditions makes clear that the government cannot condition the exercise of a right on the waiver of another right. Yet this is exactly how the criminal justice system functions today. Defendants are given a choice between immediate conviction with a light sentence or the risk of an astronomically higher penalty for asserting the right to trial. That is simply not a choice. It is a state-imposed deterrent against exercising a constitutional right. A plea bargain, as currently practiced, is nothing more than a tool of government coercion dressed up in the language of consent. It operates on the same principle as a street mugging. Give me your wallet or I will shoot you. That's a choice. But we don't call it a bargain. We call it extortion. And yet when the government does precisely this to the criminal defendants, we allow it to continue under the fiction that it was a negotiation. The idea that the government can lawfully threaten to punish an individual for exercising his constitutional rights is an insult to the entire structure of American law. The Constitution does not permit rights to be priced out of existence. A justice system that runs on coercion is not a justice system at all. It's a conviction mill, a factory for producing guilty pleas, a bureaucratic monster of the administrative state whose primary function is not justice but efficiency. The plea bargain system is a constitutional abomination, unrecognizable to anyone familiar with the original design of our justice system. It inverts the logic of the Bill of Rights, placing the convenience of the government over the rights of the individual. The Sixth Amendment does not say that the right to a jury trial exists only when the government finds it convenient. It does not give prosecutors the power to punish individuals for asserting their rights. And it certainly does not countenance a justice system where the overwhelming majority of convictions are secured without a trial at all. If a constitutional right can be bargained away under the threat of greater punishment, then it is no right at all. If the justice system cannot function without circumventing trials, then it is not a justice system. It is a processing center for government-imposed guilt. The originalist answer to this issue is simple. Enforce the Constitution as written. Require the government to prove its cases before a jury. If this means hiring more judges, building more courtrooms, and restructuring our prosecutorial system, so be it. The Constitution is not a set of suggestions. It is the supreme law of the land. And until we demand that it be followed, the right to a jury trial will remain what it has become, a fiction.
Well, the wild thing about it is that, everybody knows, or everyone can understand that when you deviate so far from what the original intent of the Constitution was, that you end up trampling on people's individual rights. That's kind of a given. But the other thing that kind of proves the originalist point, it also results in a bloated administrative state. We end up with the state of Florida spending billions of dollars a year prosecuting and incarcerating people for essentially their recreational choices or their unfortunate situation of addiction, in addition to being the personal debt collector for predatory lenders like Rent-A-Center and subsidizing Walmart's loss prevention efforts. These are the things that happen, and they're kind of convincing me of their position on how to interpret the Constitution.